Good morning, friends. Sat Sri Akal, Adab, and Namaskar. Now, this is my 260th video, and this video will be covering how record of rights were made under the settlement manuals of various land acquisition or land revenue acts of 5 different states. Now, what did Mr. Thompson, the first settlement officer, speak on in his book and under Rule 269? The remarks what he makes on the record of rights. What are the duties of a settlement officer in connection with the framing of record of rights applied to a condition of things now in past, but some of them are still worthy quoting, not only because of their interest from an historical point of view, but also because the principles laid down are of a permanent value. In the first chapter of the Directions for Settlement Officer, he observed the object of the investigation is not to create new rights, but to define those that existed. The full exercise has to be acknowledged, and still existing rights may have been partially in abeyance, and these it may be necessary for fully to develop, but generally speaking, on change should be made in existing rights or in the mode of their exercise without the full concurrence of those whose interest may be thereby affected. The process of forming the record is essentially judicial. It is judging between one man and another man, but all authoritative decisions must be avoided as much as possible. The great advantage of the procedure is that the settlement officer comes amongst the people as their friends and peacemaker rather than as their judge. The task is a dedicated one, and he must be very careful lest in the attempt to prevent disputes he excites them, and least whistles endeavoring to ally of enormosities, he only inflames them. The settlement officer would find his end best answered by doing everything as much as possible through the people and deciding nothing himself that he can avoid, and also by being most carefully that every minute feature of a tenure and every possible bearing of a right is fully recorded. Completeness of record can only be ensured by great vigilance on his part. The villagers are themselves reluctant to open to public scrutiny the internal economy of their village or by themselves. They are distrustful to slow or to appreciate the motives which lead to such inquiries. The strong, the crafty, and the dishonest wish to avoid a proceeding which will tie their hands and close every door against future encroachments, and in truth, again the process is a laborious one, which the person employed in formation of the record are apt to slur over. Each peculiarity of the tenure probably has to be elicited by a repeated question and the expression to be very carefully adjusted so as exactly to meet the case. The native of this country, not expecting those in official positioning or employees, as well as all persons who work for show and effect rather than from principles, are peculiarly prone to inaccuracy and solventlyness. Here, then, all depends upon the settlement officer by well selecting his agents and thoroughly tutoring them, and by making gradation of scrutinize. He may lessen his work or increase its polish, but all must ultimately center in himself. He must understand the subject himself thoroughly. He must accustom his mind to classify and methodize his work. He must learn to detect the weak or incomplete points of a statement. He must call into practice all these powers with unremitting watchfulness and vigilance. Above all, he must be equated by a simple desire to promote the best interest of the people, and by the uniform and conciliating exhibition of this feeling, he must win their confidence and attachment. In proportion as he possesses these qualifications, he will be entitled to the character of being a good settlement officer. Now, under Rule 270, Record of Rights in early Punjab settlements, this is what Mr. Thompson said. Directions which were followed with more or less exactness by our earlier settlement officers. Now, there is a list of some 10 things which are needed to be filled when the settlement takes place. The first of them is the Naksha Takbast, or a sketch map of boundaries with a record showing how each boundary was laid down. Sharja, or field map. Third, Khasra, or a register of fields. Fourth, a Khatoni, or a Mat Khaib Asmivar, a statement of proprietors and tenants holding with a detail of field and a note of the rent paid by each tenant. Fifth, a Tahrij Asmivar, an abstract of the Khatoni showing tenants holding with their areas and rents but without any detail of fields. Tarkbast Malguzari, or engagement of landowners accepting the assessment. Seventh, Khewat, showing the area and the revenue of each proprietor's holding. This was not a separate document but formed to be a part of the next paper, which was Ikrar Nama, or Vazibulas. Now, this is that village administration paper which Mr. Thompson regarded as the most important of all the papers, for it is intent to show the whole of the constitution of the village. So, here, friends, I will tell you that it is very important. Please, every cantonment was made of some number of villages. Where are those vasibulars of those villages? Now, number 9, the Jamabandi, a list of holding cultivated by owners, occupancy tenants, or by tenants at will, with the fields contained in each end, and some payable either as rent or revenue to the government. It was based largely on the Khatoni, but was prepared at the close of the settlements and was intended to be the first of the Patwari's annual Jamabandi. Then the last was Rubakar Akhir, a brief abstract made by the settlement officers of the complete proceedings. Now, we all residents should ask for these 10 documents of our cantonment, and it'll be a an icing in the cake if we can have the vasibulars already existing of our cantonment. Then came Rule 272, question. Now, this was very important, whether record of rights could be corrected at a revised settlement. Now, was Dr. Thompson trying to say that a record of rights of settlements made in 1793 could be revised? He believed that at a revised settlements, the record of a first regular settlement could be corrected by a simple order by a revenue officer, and that a judicial decision in a regular suit was not required. And in the settlement, under his supervision, he acted in this belief. Now, this appears to have been also the view direction for settlement officers who appeared in 1858 in Dr. Thompson's paragraphs by the book 245 to 252. Now, the directions for collectors to a description of the imperfection of the records of the first regular settlements and the duty of the collector to amend them. Some of the best revenue officers of the day, however, held that errors in record of rights could not be corrected and a subsequent settlement, except by agreement or in consequence of a degree of a court, and their view was accepted in sound in a policy and embodied in section 19 of Act 33 of 1871. Now, this is very dangerous. So that means my GLR or my entries in the record, whether it was under the cantonment code prior to the house property register, could not have been amended unless there was a court order. But Dr. Thompson thought it could be revised through a revenue order. So here now Rule 278 of the book says presumption of truth attaching to entries in record of rights. Under the present Land Revenue Acts, entries in standing records and in an annual record have an equal presumption of truth attached to them. An entry in it is presumed to be true until the contrary is proved or a new entry is lawfully substituted. Therefore, now where is this section say? Section 44 of my Land Revenue Act. Now, this may vary for Bombay, may vary for Awadh or Agra or Bengal province or the Madras Land Revenue Act, because there were 5 Land Revenue Acts made separately. But everywhere we have this section. And I have a judgment also of Ahmedabad, where the High Court Gujarat or Bombay at that time clearly held that since the owner could not prove his ownership, it deems to be a government property. So, friend, these kind of things, why am I educating you people? Is because our old grants were never converted into new grants by the Britishers. So, what were the Britishers trying? The Britishers were basically trying to siphon our old grant, or the word revenue free grant or Lucky Raj grants, which were given under the Bashai grants and the non Bashai grants, which were revenue free, to usurp these grants either from 1765 to 1790, when the entire British regime or the East India Company was holding the rights under the Diwani. Further on in 1812 or 1828, and last the 1859 Resumption Act. So these grants were neither resumed, and we were always treated as old grants or revenue free grants. Now, record of rights for Ambala was made. That is why I dug into all this. And I believe people can dig into their records for their cantonments. But this evidence is very important for the court. So, friends, please wake up. I can only is hammer you through my videos. I can only is educate you through my videos. But there are something which have to be done at ground, which you people can do it. I expect people to do it. Thank you. Good day.